Allow me to set the table first in regards to the potential of this process to add value to your business and your professional life. There are no guarantees, of course. However, if you are open to a new approach full of common sense and basic logic, the application of this process in attempting to reduce confusion, disagreements, and legal disputes by more clearly articulating in your standard business agreements on the front end is a worthy goal for all business professionals and for small and mid-sized businesses nationwide. Therefore, allow me to create a baseline first by using an analogy that the majority of us can relate to. Here's the analogy. It is a great feeling when you find someone that you connect with and you want to be around more and more. Someone who respects you, thinks you're funny, and possesses the things that you're hoping to find in a great relationship. If the connection continues to grow and you decide to be with that person longer term, either in a committed relationship or in a marriage, it's definitely an exciting time as you envision all the things you can do and become and achieve together in the attainment of your dreams and goals. It's during these happy times that your eyes are mostly on the future and all that you can envision it could become. Therefore, it can certainly throw cold water on the high that you might be feeling when one party brings up the topic of a prenuptial agreement before you actually tie the knot and formalize your relationship. I have witnessed firsthand how when that topic comes up, it can sometimes cause so much friction, so much arguing and stress, that it can be the beginning of the end. In other instances, the two parties are able to work through the legitimate concerns where their understanding, the depth of maturity, and the foundation of the relationship actually becomes stronger. Now, given that I'm not a lawyer, a marital counselor, nor a psychologist, my guess is that the person who brings up the prenuptial topic is the one who has the greater of financial assets, the one who has more to lose financially if things went south and the partnership or the marriage were to come unwound. In other cases, one or both parties are able to engage their lawyers to help them think through, discuss, and negotiate various terms of the agreement with the understanding that in the event of a dissolution of the partnership, it would hopefully be less devastating financially because both parties were more aware on the front end about what they were entering into. Sometimes that happens, sometimes it doesn't. In business, it is very, very similar. One company wants to enter into a business relationship with another company because they've identified certain areas where they can accelerate their goals. Hence, there is genuine excitement that both parties experience as they envision the positive things that could materialize as a result of a business partnership with the other entity. It is also true that the partner with the greater of the financial assets or a distribution network, or they have a product and service portfolio, etc., usually has the upper hand in the negotiations regarding the specifics around the terms and conditions agreed to in any deal. However, both parties should be aware of how costly any substantive disagreement could become. Although they are typically nervous about adequately addressing or even acknowledging those areas because they feel that it could throw cold water onto the deal, or they've got their lawyers telling them not to worry about any of that stuff, but to just focus on getting the deal done. And in the unlikely event that the relationship begins to move in a negative direction, they shouldn't worry because their lawyer has their back with something called liquidated damages. And they'll figure all that out in the event that it ever came to that. Welcome, ladies and gentlemen, to the potential of significant legal fees and resolution that could be years down the road in the event that things were to come unwound. I said years, thanks to how our legal system works with all of its inefficiencies. I believe there's a better way, which is why I am sharing this application of my process with you. Now, one caution before I share the concept around how to reduce business-related disagreements, confusion, and legal disputes. Once you tell your lawyer about this idea, I predict they will say something such as, that's unnecessary to do, since you've already got those protections in the agreements that cover that stuff already. However, had I done what I'm about to tell you about in a particular agreement that I did with a multi-billion-dollar healthcare corporation a few years ago, it would have likely saved me several $1,000,000. As you know, most professionals and small and mid-sized businesses want fewer arguments, less confusion, less friction, and fewer disagreements. Reducing their legal expense is often a goal. And there's a lesson here that you could borrow and adopt by using the concept of the prenuptial type discussion with any new potential business partner in combination with the tenets of my system to reduce the quantity and the magnitude of future potential disputes. The basic idea is quite simple. It revolves around using the basic principles of the COL system to improve the likelihood of keeping any new partnership on the up and up and on track by more clearly defining and articulating the financial consequences of what would happen to you or your company in the event of a violation of any key clause in your agreement with regard to either non-compliance or failing to meet certain performance benchmarks, etc. So by more clearly defining and articulating before you've inked the deal, the potential financial consequences that would or could materialize if key clauses are not adhered to, each party knows ahead of time what could happen, and hopefully those potential consequences would serve to keep the behaviors of each party in check and honoring the terms and conditions and the spirit of the agreement. This is all basically common sense. Spend some time reviewing your standard boilerplate contract language to determine and better define financially what it would or could cost you or your company in terms of lost revenues, lost opportunity, lost market share, in the event that key performance-related tenets of the agreement were not adhered to or met. You absolutely can and should do this. Of course, it's going to take some additional thought on your part, but don't leave it to the lawyers to figure this out once a disagreement begins. Besides, the lawyers can't figure this out without you. They need you to educate them in this area before that they can go to bat on your behalf once a disagreement begins to brew. And the education that you'll need to provide your lawyers just costs you more money at the end of the day. So be smart and do this. It's always smart to anticipate all angles in any potential business transaction. So by doing this, you help yourself and your business be more prepared in the event a disagreement begins, because the additional language that you've added to your boilerplate agreements can help the behavior of the other side to stay in check. Here's an example of what I'm referring to. You could easily insert a new section into your standard agreements, which I call the financial consequences of non-performance or the financial consequences of non-compliance, which articulates more clearly what you and or your business could stand to lose, financially or otherwise, in the event that performance-oriented clauses are not met by the specific timelines as set forth in your agreement. This is smart, and it's common sense, based on the idea as evidenced by some of the largest corporations in our nation, such as Walmart, IBM, General Motors, General Electric. Numerous Fortune 500 companies routinely use this type of language in all of their standard agreements with vendors, suppliers, and other business partnerships. So if this kind of thinking is adopted by some of the largest organizations in our own country, it should give you evidence that maybe it's a good idea to incorporate into your own business. Of course, and I'm not being disrespectful of lawyers, but my prediction is the lawyers might say something like, well, yeah, but you're not Walmart, for God's sakes. They can do this because of who they are. They're massive. They have massive leverage, but you're just a small business. You don't have that kind of clout. You can't do this. I totally disagree. You don't need to have some massive enterprise to use this basic concept. The responsibility is on your shoulders to define this up front. You don't have to gain agreement from the other side regarding the financial consequences that you come up with, which, of course, need to be within reason. It's about you taking the time to more methodically define, in whatever manner is appropriate, what the financial consequences could or would be to you and or your business in the event that key clauses in your agreement are not adhered to. Doing this more clearly and concisely up front before any agreements are signed more tightly defines, just like a prenuptial agreement, that in the event that the other party does not adhere to or perform to the terms as set forth in the agreement, it can be much easier for a court, a judge, an arbitrator, or a jury to more quickly understand, assess, and determine the appropriate level of damages for yourself or for your business. That provides you the potential for a faster resolution, for less money. Again, you must anticipate that your lawyer's response to this entire concept will likely be that the liquidated damages clause of the agreement does this for you already. However, as an entrepreneur of 25 plus years, I believe that that approach is a reactive and expensive way to go about assessing the financial damages once you're involved in a dispute with the other party, meaning the damage has already been caused. So now you are reacting and on the defensive to what you know is going to be a rejection by the other side of whatever you allege you've suffered financially. The reactive approach does not help you or your business, and it will likely cost you more in legal fees to resolve. Therefore, my humble opinion is to get out ahead of it by articulating what the financial damages could be as a result of non-performance or non-compliance. Since the big corporations do this rather routinely, why can't you? My answer is you can. The goal is to use the tenets, the basic tenets of the circle of leverage system keenly and respectfully by embracing the reality that, as I've stated throughout these videos, nothing usually happens on the path to resolution unless real or meaningful consequences are triggered, which is often what drives much of human behavior. Therefore, my advice is to take your existing boilerplate contracts and during your front-end negotiations, go through each performance-oriented clause and attempt to define what the financial range could be if the clause was not met. Again, you do not need the other side to agree. It is simply you stating that if this clause was not met, then it could cost X. This way you have a stake in the ground as you sign the agreement and move forward in the business partnership. Also, the other side will pick up on the fact that you're a very savvy business person going into the business partnership with your eyes wide open. Just like two mature adults entering into a permanent relationship, it becomes harder for the other side to argue that the financial damages to you are really not that great because they've been more clearly called up front before you inked your deal. If you want to reduce confusion, business disagreements, and legal expense, this is a very common sense approach. There is example language for your consideration which appears in the Power to Get Justice book under the section called The Financial Consequences of Non-Performance or Non-Compliance. Once you settle on language that you want to use in your standard contracts around this entire concept, I would strongly advise you to run that language that you settle on by your lawyers before you put it into your agreements so that you have all bases covered. Thanks very much for listening. I hope this was helpful. Everything that I've discussed appears in much greater detail in the book, The Power to Get Justice, which you can order by going to our website at www.powertogetjustice.com. Thanks for listening.